don't doubt that sinking in. I can see it sinking in for him right now. And he definitely doesn't want to find himself in that situation. I believe.
All right, court next calls the people of the state of Michigan versus Mackenzie Troy Carpenter, case number 252898 SM. We are here for a final pretrial conference. Ms. Lawrence appears on behalf of the people. Mr. Carpenter appears on behalf of himself. Mr. Carpenter, I just want to make sure that you're aware that you do have the right to have an attorney at all phases throughout this process. And if you decided that you wanted one and could not afford one, the court would appoint one to represent you. Do you understand that?
Yep.
Today, are you still requesting to represent yourself, or do you want the appointment of an attorney? All right. We are here for a final pretrial conference to a one-count complaint of disorderly drunk in, looks like, the city of Manton. Is there any resolution in this case?
Your Honor, the offer right now is as charged. Mr. Carpenter did make some statements possibly wanting to hire an attorney, so I felt it was better to address this on the record, but there is no offer.
All right. Mr. Carpenter, I guess I had asked if you wanted an attorney appointed, but Ms. Lawrence makes the statement that you might wish to hire an attorney. Is that something you want to do?
I consulted with a private attorney and he advised not to hire him.
All right. So it's still your desire to move forward representing yourself?
Can I enter a plea?
You're representing yourself, so.
I'd like to enter a plea of no contest.
Well, there's only certain ways that the court can do that. So what is the reason for no contest plea?
Can you elaborate?
The court can only accept a no contest plea under certain situations. And some of those situations might be civil liability or something like that. So what is your reason for requesting a no contest plea? No. We're not going to have that. Bailiff, can you put her one row back, please?
I don't want to overspeak your Honor, but if you wanted me to, I could speak with him briefly to express what the public defenders might be able to do for him. I trust the court's discretion. I apologize for my
Are you okay with that, Mr. Carpenter?
Wouldn't be in favor of that.
All right, Mr. Hartel, I'll give you the moment to do that.
Sir, can we talk for a minute? I appreciate it, Your Honor.
Yes. We are back on the record in the people of the state of Michigan versus Mackenzie Troy Carpenter, case number 252898 SM. Mr. Carpenter, I know you had the opportunity to meet with Mr. Hartel, and I think I heard him say he was filing an appearance. Are you now requesting the appointment of an attorney?
Yes.
All right. All right, so then we will, and Mr. Hartel, you're prepared to do an immediate appearance on that?
I am, Your Honor.
Have you had, well, looks like you had the opportunity to speak with the prosecutor's office, and since I've been given an exhibit, looks like we probably have an agreement. Is that correct?
Yes, Your Honor. I believe the defendant will plead no contest as charged.
No contest is charged, and the reason for the no contest plea?
Intoxication levels, Your Honor.
That is accurate, Your Honor.
Mr. Carpenter, have you heard what the attorneys have said the resolution in this case is? That you'll be pleading guilty as charged, but no, I'm sorry, you'll be pleading no contest to the charged offense of a disorderly person drunk. And the reason for the no contest plea is lack of memory due to intoxication.
Yes.
All right. And you understand that that is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In order to accept a no contest plea, the court is given something to review. In this case, it looks like it's going to be a police report. I would review that police report to see whether there's a factual basis to accept a plea or a finding of guilt. No contest means that you accept the responsibility without saying that you're guilty. Do you understand that?
Yes.
And I would be able to use that police report for sentencing purposes. Do you understand that as well?
Yes, Your Honor.
Ms. Lawrence, I've been provided with a Michigan State Police incident report number 071-000 2129-25. Do the people move for its admission?
Yes, Your Honor.
Mr. Hartel?
As do we, Your Honor.
All right, People's Exhibit number 1 is admitted. Give me a moment to review that. Counsel, I have read the report. One issue that the court has is there's no level of intoxication in it. So there's nothing in the report to indicate that there would be a high enough level for lack of memory. For no contest.
No, Your Honor, my client would be willing to make a limited statement that he does not recall those events because he knew he was intoxicated. I don't know if that helps at all.
Let's give it a whirl. Mr. Carpenter, will you please raise your right hand? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. Hartel? Do you need to report?
If I could have that back. I appreciate it. On June 28th at approximately 2 o'clock in the morning, do you remember anything at all from that period of time?
Waking up in
Before that, had you done anything that would have impacted your ability to have recollection?
I had drank personally and at a public house.
How much do you think you would have consumed over what period of time?
3 doubles in less than 2 hours.
Doubles of what, sir?
5.
That's quite a bit, Your Honor. I'm not a medical expert, but that feels like it would be enough.
Mr. Carpenter, what is the last thing you remember before waking up in handcuffs?
Being offered a ride from a friend and saying, no, I can walk.
Ms. Lawrence, are you satisfied with that testimony?
Yes, Your Honor.
As is the court, I find that the defendant in those situations is experiencing a lack of memory. May I have Exhibit 1 back,
My
please?
apologies, sir.
Do counsel believe that Exhibit 1 provides a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
As you are, Your Honor.
As does the court. In particular, the report indicates that on or about Saturday, June 28th. Sorry, we didn't take a plea in this, did we? I think we skipped that step. Mr. Carpenter, to the allegation that on or about June 28th, 2025, in the city of Manton of Wexford County, how do you plead to disorderly person drunk?
No contest, Your Honor.
All right. Now to where I was, the state police report that they were called on June 28th, 2025 at approximately 02:18 in the city of Manton to a person who was an unresponsive male laying in the front yard and driveway. When law enforcement arrived, they encountered Mr. Carpenter, who was lying face first on his stomach, but breathing. However, he was unresponsive, had to be subjected to sternum rubs, and when he did become responsive, he tried crawling away from the roadway. Law enforcement could smell the odor of intoxicants coming from his person. He was placed in handcuffs and detained for safety. He attempted to stand up and walk. He was swaying back and forth. And as he stood, he could not walk due to his high level of intoxications, as they quote out of the report. Additionally, his speech was very slurred. He became agitated before screaming at law enforcement. And then it goes on to describe somebody that could have easily been charged with the resist and obstruct law enforcement. The court finds that the report makes these, provides a factual basis to accept the plea. Mr. Carpenter, I find that you are guilty of disorderly drunk. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea due to his perceived level of intoxication and lack of memory. Are we able to sentence today?
Yes, Your Honor.
Elocution, Mr. Hertel?
Yes, thank you, Your Honor. I do appreciate the court allowing this to be no contest plea, as my client did note. He has very limited recollection of those events. And I did meet with him, albeit briefly earlier, and I do appreciate the court for letting me do so. He did make it clear that wishes he wouldn't have found himself in that situation, because even though he doesn't recall all of it, he recalls waking up in the squad car. He recalls everything that's happened after that. And the embarrassment he believes that most likely causes for his family as well. If I understand correctly, that is your mother. His mother is here, because I'm sure the court did note. He did advise me that he does plan to go on, if allowed, a family vacation to North Carolina on October 3rd for 4 days. I did want to get that out there just so the court's aware. To my knowledge, he hasn't had any issues on bond. He's been using the sober link multiple times per day. I would always in these cases ask the court to consider fines and costs only. Because I was barely involved, I of course waived my attorney fee. If the court did believe this is a situation where either jail or probation would be required, I would ask the court to factor in that doing good on bond, in my opinion at least, means he is supervisable. So even though I'd ask the court to limit it just to cost, if there was a choice between the two, I'd ask the court to go with the supervision. If so, I would ask the court to fashion an ability for him to be able to go on that pre-planned family vacation. I do believe his mother would be with him for that portion of it. We do, of course, trust the court's discretion. I would throw in that based on my discussions with him, I do believe he doesn't have any recent criminal activity. So I do believe there was at least a significant chunk of time where he did not have issues with law enforcement. I am told that there was things in his past, but he has no desire to go back down this path. And unfortunately, things like sobriety, we do have slips sometimes, but he definitely has no desire to, as the court did note, this almost rose to a felony situation.
I don't think it almost rose. I think it was there. It just wasn't charged as one.
Noted, Your Honor. And I don't doubt that sinking in. I can see it sinking in for him right now. And he definitely doesn't want to find himself in that situation. I believe the fact he's done good with the sober link proves how sobering this has been. And even these words right now between you and I can tell are sinking in just so the court is aware. Thank you.
Thank you. Ms. Lawrence, on behalf of the people.
Thank you, Your Honor. I know I don't need to go into too much of the facts since you just read the report, but I will say I did have an opportunity to review the body cam footage in this case, and the report is being generous. If I'm honest, Mr. Carpenter was extremely loud and rude and disrespectful and not compliant with these two troopers. Based off of my conversations with him, I don't believe he truly thinks he did anything wrong. Given that, I would ask for 5 days jail. I think also with his 2 prior convictions involving alcohol in the last couple of years may tell us that there might be a deeper problem here, so that people would ask for 5 days jail. Thank you.
Thank you. Mr. Carpenter, you have the right to address the court before sentencing. Is there anything you'd like me to know?
I would just like to apologize.
So it looks like you've been on the SoberLink device since, well, I ordered random testing. So did you opt for the SoberLink? And you've been on that the entire time you've been on bond?
Yes, sir.
How are you finding not consuming alcohol?
That's not an issue.
Okay, all right. I have no violations, so that's a good thing.
I actually have a more difficult time with the 11 p.m. and 6 a.m. with my work schedule.
Okay. So I show in 17, there was a case handled under 7411. And then in 20, there was an operating while visibly impaired, and 21, an open intox. So that indicates that there's some issue with alcohol. Have you been sober since then?
Yes, actually, I had over a year of sobriety from 24, the September of 24 to September of 23 to October of 24. Unfortunately, fell back into bad habits.
What have you been doing to get out of those bad habits?
Maintaining a steady work schedule is a big part of it. I do work seasonally, and because I see a direct connection between the off-season and my drinking, in February, I'll be moving down to Fenton to take on a factory position that's year-round.
What type of seasonal work do you do?
I work for Mosquito Authority out of Kalkaska.
Okay. Do you think that you can continue to work the services that you need to work without probation hanging over your head, or do you think it's going to be beneficial to have probation out there?
I think the guy, I'm sorry, I don't mean trouble to be disrespectful. I think the guys at my local meeting would really appreciate seeing me there. Without probation to have anything to do with it. I think they'd be very happy to see me.
Have you been attending meetings?
Yes.
All right. Did that start after this case arose or before?
No, I've been going infrequently, less than once a month. It has increased since this event.
Okay.
Work does make a difference.
Well, and there's online meetings as well, if you've got the ability to do those. Anything else you'd like me to know? All right, there will be 1 day jail with 1 day credit. There is a $75 crime victims' rights fee, $50 state minimum fee, $150 fine, $150 court costs. We'll waive the attorney fees. I'm not going to put you on probation. I'm going to trust that this was enough of an eye-opening experience that you've seen what you need to do. You've been on SoberLink since back in June, and I don't have any issues, so that tells me a lot. But I want to caution you that, and you know this, that once you're off that SoberLink, it's entirely up to you as to how you move forward. The choice is only in your hands. I wish you the best of luck with that. And you know what you need to do. You said that you had a period of sobriety. So because I have sentenced you to 1 day jail, even though it's credit for time served, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you in that regard, you have 14 days from today's date in which to request the appointment of an attorney. And any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. All right. I'll need you to go out to the front window where you checked in, get a copy of your judgment, make payment if you're able to, and then you can go downstairs to community corrections and turn in your device if you have it with you. If not, make sure you do that tomorrow. All right. Thank you. Best of luck to you, sir.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.